On behalf of Foundation for India and Indian Diaspora Studies, a policy, studies, and advocacy platform, we are hosting this event on the legal immigration policies, changes, and the impacts during the Trump 2.0. For this session today, we have two prominent attorneys working in the immigration space. Seema Mehta, she's from the law firm of Seema Mehta from Dallas, and we have Neeraj Bhatia, who is a CPA and attorney. He's from Bay Area, California. Before we start, I would quickly share FIIDS information presentation. So FIIDS, as I said, that Foundation for India, Indian Diaspora Studies, we work on the policy issues related to India and
as a US-based non-profit organization, Foundation for India and Indian Diaspora Studies, FIIDS' mission is to engage the Indian diaspora in the United States to further strengthen collaboration in geopolitical security, economic policies, education, science and technology, and people-to-people engagement. We focus on building strong US-India relations on related policy matters. FIIDS is an institute for research, analysis, awareness, and advocacy on events, issues, and matters related to India and Indian diaspora. FIIDS monitors, builds, and events to analyze the impact on Indo-Americans and to come up with strategic responses to address narratives. FIIDS also keep a watch on international human rights violations, hate crimes, and acts of terrorism. To create awareness of important policies or issues, FIIDS has successfully hosted conferences on various topics ranging from international relations, US and South Asia, Indo-Pacific, trade, terrorism, human rights, genocide in Bangladesh, minorities in Pakistan, or situation in Afghanistan. It also works on international relations like US-India-Israel, US-India and AFPAC, Indo-Pacific, and Indian Ocean Rim Association. FIIDS also conducts regular surveys and publishes studies on Indo-American youths and their identity, US elections, NRI policies of the Government of India, and the opinion of Indo-Americans on policies and elections in the United States. FIIDS has published papers on the abolition of Article 370, position of India CAA, atrocities in Bangladesh, rejoinders to annual reports, USCIRF. FIIDS is also engaged in various issues like incidences of intolerance against Indo-Americans and immigration issues like visa appointment delays or country-wise cap on green cards. FIIDS also focuses on skill development to build strategically important capacity in the community. FIIDS hosts annual congressional summer internship program for undergrads and a structured internship program for high schoolers. We host regular workshops and topics related to advocacy as well as organizational needs for Indo-American organizations and community leaders.
As said in the presentation, we are a policy research and advocacy platform. We monitor congressional policies, administrative rules, regulation changes. We also host the advocacy summit mostly in the Capitol Hill. Our marquee programs like all over USA, almost 150, 200 people, delegates. They come to once a year in Capitol Hill and presenting, discussing various topics, including the immigration with the lawmakers. We also host separate similar immigration related summit on a Capitol Hill, and the policies like green card delays, 7% quota limitations, H-1B extension during the layoffs happened. That time we had done campaign to get some relief for the laid off H1B professionals. We also worked on the OPT related matters, and it is ongoing as administration come. Every administration there are different policies and views. Now with Trump administration in picture, it is more focused has been on the illegal immigrants. That was one of the major driver on that illegal immigrants and then so that campaign while it is going on, there is also overall structural or the policy related aspect which impacts even the legal immigrants, so particularly H1Bs or the green card holders, and so a lot of things are happening. So you may have seen a lot of news items which may impact and which may be worrying to tech professionals or illegal legal professionals. On this background, we are hosting this session. I will be inviting the uh, one is Neeraj Bhatia ji, and then Seema ji on this particular session. And one by one, they will be doing first 5 to 7 minutes of slide presentation. And that instead of the broader policies, only the policies which either there are changes or there are immediate impact. So those are the things covering from EB5, even the gold card to H1B. So we are trying to cover that very higher level, and then I will have some questions, and then whatever the questions that audience may have, you can enter them, and then we can pick up some of the questions, and I will be asking that so that it will be more efficient into that. So we'll start with Attorney Seema Mehta. So Seema ji, you can start with your project presentation. You can share, and you can start with that.
Hello, everyone. I hope everyone's having a great day. My name is Seema. I'm an immigration attorney for past many, many years. Over 20 years as an attorney, and before that worked as a paralegal. And I primarily work with EB5 investors and, of course, the standard non-immigrant visas, which would be your L1s, H1s, EB1s, EB2, EB3 kind of visas. I don't have any slides to present to you guys. I was actually, I guess, under the impression that we have a question answer session today. But well, given the current sphere, I don't think for legal immigration much has changed except the timelines, except the news bites that you hear on TV. Not much has changed. People who are, I guess most of the people who have joined in today must be H1Bs or L1s or maybe a few students here. Not much has changed in your sphere. You would be filing for extensions, you're good. You'd be filing for maybe an EB1, EB2, EB3. The timelines have not changed much. I don't foresee any more delays. It's already quite delayed. Students, yes, I've heard a lot of students having issues, but I've seen if it is students who reach us for any problems, have been students coming from maybe much smaller universities, not a good degree that they are pursuing, or something in the background. I have not thus far come across anyone who has had an issue despite having a very straightforward immigration timeline or your background. So I don't foresee anything for legal immigration which is impacting us in a very substantial form. If you have any particular questions, please feel free to send it to Mr. Khandirao, and we can talk about them. We have an influx of EB5 investors coming from your H1B and L1 community, given the long timelines that you see, which have existed from quite a few years now. So I think that is also not changing. It seems to be stuck somewhere in the timelines. So, that's where we are. I think there was one issue that had come to the forefront, which was about a lot of people saying they are being stopped at the airports I've had two of my own clients who have returned after 1 year. One of them was a Saudi national, another one was a Pakistani. It was not Indian nationals who were stopped at the airport. One returned in 9 months, who was a Saudi, and the Pakistani gentleman, I think 11 months with the whole family. And they were questioned extensively as to why they did not come back. And fortunately, we'd already had our conversation over that, and they had legitimate reasons to explain, at least, to the CBP officers. So that's the only thing I've seen, which I've heard from my own clients. What else can I tell you? I think also that a lot of you who are going in for your visa stamping are seeing maybe admin process, a little bit of extra questioning by the officers, which happens each time an administration changes. And this administration seems to be a bit, the feeling around the common feeling that people get is that they are against immigrants, whether it's legal immigration or it is illegal immigration. But that is not true. I think the questions that are being posed to my clients, even on H-1Bs, have been where the company that they work for is not legitimate or has had some issues. So I would tell everyone first and foremost not to worry so much. Though the administration has changed, there's nothing much to worry.
Thank you. Thanks, Simaji. What I think she mentioned that at the regulations and rules level, at very higher level, there are no changes. Just to clarify, everybody, there are three entities are there. Congress is where the policies happen. Like say H1B, how much quota needs to be there. So Congress basically approves that. Similarly, say 7% country-wise quota is another thing that it is also decided by the Congress. Then second part is that procedural changes. The procedurals, which is the administrative, which is the USCIS, United States Commission on the Citizenship and Immigration Services. So that actually has the procedural aspect of it, and they may decide on certain procedure. And then, of course, the State Department under that two things comes into picture. One is that the consular services, which comes into the State Department. And these consular services, typically the policies may vary, like say how strict or lenient that interviews can be, etc. Similarly, port of entry that comes into that, that's a similar thing. And then Justice Department, or the what we call is a ICE, which is a now the much more you have seen in the news. The some raids are happening and queries are coming, etc. Including the colleges, which is mainly targeted toward the illegal immigrants and criminals, etc. Because it's a scale is so high, it is not no, possible to go after the legal immigrants. However, there are certain more scrutiny happens. You may see more queries, even the certain complaints of fraudulent practices, and those complaints they get received, and sometimes ICE may even do the queries or the raid on the workplace kind of prohibits the fraud that people are from their LCA or anything. One location has been mentioned, but they actually doing something else or somewhere else. So those are the things. Though the visa is valid, but the scale of this, I think, is as Simaji said, it's not that higher level. So we'll go through now Neeraj's presentation, and then I'm noting down the questions that as they come, and we'll try to get it. Okay, Neeraj, please go ahead.
Good evening, everyone. My name is Neeraj Bhatia. I'm a CPA and attorney. Maybe I'll just start the sharing the screen. Are you able to see the screen?
Yes, yes.
Okay. Yeah. So basically, Simaji is probably going to talk about the EB5 and And Khande Raoji also covered some things on the um, uh, something on the EB5 and the recent inquiries at the port of entry and others, and probably little bit some of the changes which are anticipated are the golden rule which President Trump announced, and Commerce Secretary Howard Lutnick announced about the abolition of EB5, but nothing really has been done on that so far. And because EB5 is congressionally mandated, unless there is a change in no, so that definitely can't be done through an executive order, but with this administration, anything is possible. And then there are, of course, litigations on those fronts. So maybe Seema, you can throw some light later on, because I'll cover on two basic things. One is the layoffs. There have been recent layoffs, and also a lot of uncertainty is there. So H1 and other non-immigrants, if they get laid off, what are their options? And also some tweaks in some H1B regulations have been there recently announced, and some on F1. So I'll just cover those briefly. So this is a brief background. I'm a CPA and attorney. I have a CPA firm since 2000, and I'm a chartered accountant from India also, and I'm an attorney in Bhartiya Professional Law Corporation. And these some of my qualifications and positions I'm holding with various organizations. In the layoffs, first of all, you normally now get a 60-day grace period. So if somebody on H1B, E1, E2, E3, or L1, O1, or TN are laid off, till 2016, there was no grace period, not even a day. So literally, if somebody was laid off at 5 o'clock in the evening, there was no way the person could be legally, could comply with the law, because he had to go out of status the very next morning. But fortunately, since 2016, 60 days grace has been allowed. And so they have permission to remain in the US for 60 days. And that provides time for looking for other options during that time, while retaining their status for themselves and their family. So during this grace period, they can port their H1 to another new employer, or file an application for change to another non-immigrant status. Or if they're eligible to file a 485, file for adjustment of status. And now recently, due to some clarification, even startup H1Bs are also possible. It was there before, but it's been clarified that even entrepreneurs can do their own H1 through their own corporation. We'll come to that. And also there is an option to do compelling circumstance EAD in case situation warrants. So, and during this 60 days, if they do take one of these actions, the period of stay can get extended till the adjudication is there of the, let's say H1 extension has been filed, change of status has been done, or transfer has been done. So then till the adjudication of the new application, they can continue to stay. But if no action is taken, they have to within 60 days depart the US. So the 60 days grace period starts from the day after termination of employment, and it applies to both voluntary and involuntary cessation. So basically, if somebody resigns, still they can avail of the 60 days. It's not just a layoff. So for any reason, if somebody resigns because they cannot get along, or they don't feel comfortable in the company, it allows the spouses and family members also. And spouses can also continue to have their H1, H4 EAD valid during their this 60-day period. And the eligible H1B can start working immediately the moment new H1B has been filed by the new employer. Let's say after 35 days, they find another H1B employer. They can start working immediately upon filing the H1B. But if there is a change of status, change of classification, then they have to wait for the approval. While filing the subsequent petition, the applicant will have to write that they are using the 60-day grace period. And even they can be hired by the same employer, And but again, in case in between they travel out of the country, the 60-day grace period ends. And it also doesn't apply if person is out of the country and then they come on H-1B and then they want to use the 60 days, then it will not apply. So now for F1 students on OPT, so during the post-completion OPT, the F1 status is dependent upon employment. So they have to comply with the strict rules of the employment. That is very critical. Students may not accrue an aggregate of more than 90 days of employment during any post-OPT completion. So for them, it's a different rules than the 60-day for H1. And STEM OPT may not accrue or aggregate more than 150 days on employment in OPT plus the 24 months extension on STEM. Now, gap extension for F1 is once now the H1 filing season is there till 24th. If somebody files an H1B on their behalf, they can get a gap extension. Earlier, it was till October 1st when the new season started. But based on the recent changes which have been done in January, they can get up to April 1 of the next year. Till that time they can get, because if the adjudication of new H1 takes time, till April 1 they can get their they can stay in the country till that time. So, and hopefully till that time the new H1 will be adjudicated. Of course, they have to comply with all the regulations, and so after filing the H1, even if the OPT or their EAD employment terminates, they can still continue to stay there based on the cap extension filing. Now, H1 people, they can port to a new employer. They are eligible to work immediately for the new employer as soon as the filing is done. And a worker who has an adjustment of status pending, and that has been pending for more than 180 days, they are not affected because they can also transfer to a new employer based on the 180-day pending. These are the existing rules for those who have adjustment of status pending for more than 180 days. So they can work for a new employer without any restriction. Of course, the new employment has to be, because they ask questions. They've asked them to file J supplement at the time of 485. So the employment has to be related with the same classification. So, and if they are doing a change of status to another classification, let's say L1 is transferring to an H1 if they are eligible, or to B1 or to F1 student status or anything else, then timely filing of the non-frivolous application will stop the unlawful presence. So they can continue to maintain their status. Of course, they cannot work in those, if one of those categories allows them to work, they cannot work in that category till the approval. And status can be changed to, they can even become let's say the spouse is on H1B, they can even change to H4 or L2 as a dependent spouse.
You are muted. Somehow you got muted. Neeraj, you need to unmute and speak.
Can't find.
Okay, now you're okay.
Okay. I don't know. I couldn't find how I got muted. Anyway, so for there can be an expedite request in certain circumstances where there is a for expediting an H1B or other change of status. In the criteria is that there is expected to be a severe financial loss to the company or the person, or there are emergency for humanitarian reasons, or if it's a non-profit organization in furtherance of their cultural or social interest, and certain other categories are there. In the case of adjustment of status, that's where they are eligible to file 485 if the priority date is current in those categories. And in some cases, if they the candidate, the individual thinks they are eligible, they can do self-petition also, especially if it is EB1 category for persons of extraordinary ability, or in the case of EB5 investor, they do, because the priority date is current as of now for most of the countries. So those can also be done. And where workers with a pending adjustment are generally eligible to remain in US and obtain an EAD in most cases. And as we said, if they are pending for more than 180 days, they can also move to a different position. There is also some compelling circumstances. There is a special EAD which can be done in special cases. Of course, this is where I-140 is already approved, and it's about to come up. So there are very, very special cases, and some limited circumstances are there. Now, H-1B now, in one of the clarifications in January announcement, they have said that H-1B people, if they have ownership interest in the companies, they are eligible for doing H-1 through their own entity. This is generally for the startups, which is commonly called startup H-1B. It was earlier also there, but it's now explicitly mentioned in the new regulations. So of course, all the requirements of H-1 have to be met. So they can have ownership interest, but it doesn't mean just by merely being an entrepreneur or employer, they can get an H-1B. They have to qualify for the specialty occupation, which requires all the H-1B requirements of being eligible, both the specialty occupation, both in terms of the employer's degree requirement and the employee's education requirement, both have to be met. And it is same way, 3 years approval with 3 years extension, and all those conditions are there. So basically, the only thing is they can have, but generally it is better to have a separate a board of directors, where the employer-employee relationship can be established, that it's a separate entity, not just the individual having a sole proprietorship who's doing it, which really raises too many question marks on that. So to have a separate employer-employee relationship is still important. So if there is an independent board of directors which is appointing this person, it'll be that's what is desirable. Certain changes which have been recently there, other than this, is that there's a tweak in the specialty occupation definition, because the education earlier, they were some of the guidelines, especially in the previous administration, they were very strict on the education degree in that same occupation. So now they have said it can be directly related. Bachelor's degree or higher in directly related field is necessary. So directly related means logical connection between degree and duties. It did not be strict separate same degree. So then normally doesn't necessarily mean always for degree requirement in that field. So it allows for a range of qualifying degree fields, and each field must be directly related to the job. It need not be strictly in that same word. So there is a lot more flexibility for employers in identifying qualifying occupations, and emphasis is the connection between education and actual job duties, both the things. So then USCIS is also codified difference in policy that if there is a prior determination, they will not reopen on the same issue, because we have seen a lot of RFEs being raised in the past, where on the same issue, let's say for the degree or for the job duties, on the same issue, let's say some employer is filing for a renewal after 3 years. USCIS used to raise query on the same issue again, which was not there earlier. Either it was not there, they would start questioning the job duties of the same position or education qualification. Now they have a policy guideline that USCIS officers should defer to the prior determination and not question the same thing from the same party and the same facts, unless there is a material change or material errors have been discovered. And even for H1B requirement, some specialty occupation, some definition changes are there. It has to be bona fide specialty occupation. As you know, position is availability for the requested start date. These evidence, they may ask for this about the special, that there is a position requirement from the date of H1B eligibility. Then they may ask for a contract where especially where H1B people are working at outside third parties. So which was not a written rule, but they were asking. Now it's many of these guidelines which have been there, they have been now mandated in the law. So an LCA alignment with the position is one of the requirements. And legal, but now one of the other requirement is that it has to be a US, the employer has to be present in the US. Earlier, that was not required. A foreign entity could file an H1 for somebody in the US. Now it's mandated that it has to be a US employer. Then US site visits of officials has also been in a way mandated. Earlier, many times the site visits were conducted by USCS officers, which was in a way a gray area. The way they were coming, they many times did not have authority, but somebody would come, show up at somebody's workplace. Nobody can, I mean, people would normally not have the guts to say anything to them. They would just comply with whatever were there. But now it has been specifically affirmed that they have an authority to conduct site visits, and the non-compliance may lead to denial or revocation. And for the third party site where the candidates are working, individuals are working, the rule has clarified that the requirement or job duty requirements of the third party rather than the petitioner's own job requirement will be important. So that's why they can ask for the contracts and the job duties from the third party, where the focus will be where they are actually performing the job. One of the positive thing is the itinerary requirement, which was there in H1B. It was eliminated earlier, but again, that has also been mandated now in the regulations. Now for non-profit organization also, there are some tweaks that the non-profit research organization, because they are cap exempt non-profit research. So there is some change which has been there, that for the non-profit research organization, that should be their fundamental activity, but it need not be their primary activity which they are engaged in a way which it's meant that even they can use supporting organization for this. If their own fundamental activity is non-profit research, they can use other organization. 50% of their time for essential work has to be for the supporting organization's purpose, and the activity there it should support their mission and objective and function. So it just increases flexibility for these non-profit organizations to do an H1B. And remember again that these are cap exempt, so they are not. If somebody can find a job with one of such organization, it won't come under the quota. So this is briefly, I'll leave it to
So thanks,
Thank you.
Dheeraj. So you can stop the screen sharing, and then I will bring Simaji also on spotlight, and then we can start. So I have compiled the questions in the categories, and I will basically go through that some of the categories. So and then I will redirect some of the questions. So first thing that I will start with EB5. So EB5, is it going to continue or cancel? Because there was some announcement over there that GC gold card getting introduced and EB5 is getting replaced. So what is the current status on that?
Of course, it will not be replaced. It is a law by statute, and the Congress has already created it. It's not going anywhere. EB5 has been under fire since I've started doing it in 1996-7, I think. So that is that little soundbite and a lot of press conferences talking about it. That this is a program full of fraud. It is at certain level. It is. I have seen a lot go wrong with EB5 as well, but it's not going anywhere. The gold visa, if it happens as they're planning in say next 2 weeks, it was supposed to be 2 weeks before 2 weeks, and now it's again 2 weeks. If it comes, I think as a US citizen, I love the idea. I do hope they get their million people to take away all our trade deficit, but that's a far-fetched plan in the mind of the government. EB5 is not going anywhere. By law, anyone who will file EB5 before September 2026 is grandfathered in. That's why we are seeing such a huge influx of all the non-immigrants trying to file EB5 by hook or by crook.
Okay, thank you. So there are a group of questions are around the questioning and visiting to India. So there are questions around I'm on H1B. Is it still safe to travel? My parents are there in India, and they're elderly people. Their gaps basically 5 6 months, and then whether it's going to be questions. So Niraj, if you get to the port of entry, any issues onto that?
So this was there earlier also. The only thing is there, the scrutiny, the questioning is a little more. Of course, we are hearing the news that they are forcing people who are coming to voluntarily give up by getting them to sign I-407. But I think obviously the people have to be aware that it's a voluntary form. They don't have to sign. They can't be forced to do it. But of course, in the questioning, they think from the facts that they don't. The officers start determining they are not living over here. So the people who are coming have to be prepared to answer these questions properly and not get intimidated at that time. And be the important thing is be properly prepared for the situation.
So
Our
one
clients do ask before many times who are coming, especially after longer stay. And then that is what they need to understand. And because if they sign, then they are in a way saying that they are voluntarily giving up their green card.
So, so basically, you need to have some sort of a valid reason to stay out of country for a longer time, and then also you should be able to present it. But don't get succumbed to the pressure. There are reports
Correct.
that
During COVID,
port
there
of
was
entry.
laxity. They had allowed more than a year also stay
Yeah,
outside the US because
yeah,
of this.
but right now there are reports that they are getting questioned, and there are reports that port of entry officer may also ask to sign I-407,
407, yeah.
which is surrender. And if
Surrender.
if the people, particularly parents, may not be familiar with I-407, and they will ask to sign the form, and so I think the clear guidance, if any one of you would like to give on that.
So
You
basically,
sign the form.
yeah, go ahead.
Go ahead. You go ahead, Neeraj.
No.
Go ahead.
No. Basically, they have to be prepared. They have to know what it is. They have to be able to explain the reason why they have been staying for longer. And of course, unless again the circumstances warrant them to go briefly stay for long duration, they have to justify that they are permanently going to come
No,
back
the
and stay
question
for
is
long.
not about that. The question is that, say, I'm entering and all this justification gave, and they gave that, okay, now you sign this form 407.
No, I don't think
So
they
there are
really
reports. There are
they
reports. There
No,
are
but
reports out there.
Khaniraji, it is quite similar to where this everyone's heard of a Lebanese doctor not allowed to enter. And after that, the next day, I had a gazillion doctors texting, calling, emailing. We are traveling. When we are coming back, are we going to be stopped? You have to go back and see who are they, who did they really stop? Just don't go by the
I
news
think the question is not that. Question is not about the case. The
that whether
question
you
is
are going to
that
be able to
very
sign.
specific question.
Uh-huh.
I'm entering into the port, and I being asked that, okay, this is a form. Can you sign that?
You're supposed to say no.
Okay, so that is the answer for everybody. That if your parents are asked to sign anything, they should basically they have right to reject. They are not basically supposed to do. The port of entry officer can actually give a date, or from the court hearing can decide that they can continue or not the port of entry. So that is very clear guidance I think parents needs to have.
Definitely, definitely. But I think this fear factor also needs to go because
Correct, correct.
everyone is being inundated with these questions. It is not true. It is not true that every parent or anyone who's coming after 8, 9 months is being forced to. They are being questioned. 6 months, no. I see a lot of questions on the side where they're asking about parents coming back about in 6 months. That's standard. There's no problem in them coming back.
Okay, so then there are other questions are around that whether people should be postponing their travels or should not be traveling in the situations where either the visa is expiring soon or even there are concerns that having even the valid visa, they are also expressing the concern about that. So any concern about traveling. And this has also triggered because when the Trump administration took at the 20th January something, many universities has clearly asked the students to return to campuses, and that also has fueled. So anything that we are saying that guidance to the people that they should or should not be traveling.
Only the H-1Bs if you don't have a stamp. And if you're not working for a great corporation with very good documentation, and then if you're traveling out, you're working at a startup, you've just been there 1 year, the startup doesn't have enough tax returns. When you go in, they will give you a blue slip. But if you are a standard H-1B, you've been here 7 years, you have your I-140 as it is, you don't need to worry. There's someone asking if I'm a green card holder, can I travel? Yes, there is no reason not to travel. There is no reason to be so fearful about anything. Of course, if you're a green card holder who's lived out for a year and now you're returning in, definitely they'll ask you, how come you're a permanent resident of the US, but you've not lived in the US? So you should be ready with a legitimate response at that time. In
So
other
just a follow-up on that, someone asked that question that should they be carrying particularly green card holder, carrying some extra documentation or just not needed?
So for us, my primary clientele being EB5, these guys have their businesses back home in their countries and they do get their permanent residency and they travel back. They come back in 8 to 9 months most of the time if we don't get them a re-entry permit. At that point, you have to come back with a legitimate explanation that yes, I'm a permanent resident, but I was in my home country because maybe I was trying to sell my business so I can come and settle down here. Or, not that, okay, my mother was not well and I sat back, or that I have a business which I need to run in that country. So you have to talk to your respective attorneys if you have a longer time duration.
Okay.
Yeah.
So three questions are related to OPT. One is that now graduation completed. And so basically, I'm finishing the education. My visa is still valid. That's the one case. Another case is around the OPT. I missed a few payments in the OPT. Are there going to be the concerns around that? And then currently on no, OPT, need to go to India for emergency medical condition for a month, and I can get the travel signature, etc. Client, is it safer to travel? So these are the three questions related to OPT, if you can look at
What is
it.
the payment? What payment
So
missed on?
basically, during the OPT, when you are working, you are getting say salaries from your employer, but then might have missed it. So missed it means that not paid. So probably not working, or probably might not be in country, but they are not having consecutive salary
So
slips.
on OPT, basically they have to have proof of their working. In OPT, one can be on a completely voluntary basis also employed, but not on STEM OPT. STEM has to be a paid employment, whereas that can be voluntary. Of course, they have to have some justification documentation that they are working. Whether they are paid or not is not shouldn't be that critical.
About the travels, like say studies completed, visa is still valid, should go to like a F1 visa is still valid, should go to India or not. So basically, it's like they completed this one, they still finding a job and then trying to ask that whether it is safer to travel.
Yeah, if they're still finding job, then it becomes a question mark, because then justifying that they will have a valid employment as for on OPT, that obviously raises the query. So it's best to have an employment, then only travel, to be on the safe side, rather than just go and then come back and then now, okay, I'm coming back and now I'll start looking for a job. Obviously, that
And they
will,
just delay the completion, the graduation itself. So is there anything?
well, they,
You're mute. You're on mute somehow. Repeat, please. Can you repeat? No, I think Simaji want to address that.
No, no, that is perfectly fine. There's no need to delay, as Neeraj already, I think his slides had covered these things. How long can you be without those pay slips that you're talking of, or whether you should be traveling while you don't have a job. What will happen is you're going to come back in, the officers, all F1s, generally coming from our sphere of the world, will be questioned. I've seen almost 40 to 50% of the students being questioned prior admin or this administration. So they will ask you. And then if you don't have a job, as he already said, yes, they are going to have doubts, but what will happen? They'll keep you there for 2 hours, 3 hours, be calm, stay there, answer everything, say I've interviewed, and come back in. Stamping is the issue in traveling, not coming back. Coming back is an issue if there is some issue in your visa as it is, which of course is an individual issue. We don't really need to cover here, but otherwise, travel on.
So there are three questions around the children of H1B, or those who are sometimes in a GC. The one case is that child is now 20 year completing. Should what should the advice? Another is also like the question is coming right. When should they convert from H4 to F1?
Okay, so
Yeah,
I go.
because they will be aged out and they will be no
Yes,
more
aging out
dependent.
is a horrible, horrible problem. More than anything else, I feel the aging out is a big issue. You have to make sure, because we are allowed to file for a change of status before 6 months. Just keep an 8 month window and file for a change of status if you are not filing for something else or eligible to file for your adjustment within that time period. So yes, within, I mean, legally speaking, 6 months prior to that. Otherwise, I think within the last year, anytime you move to F1, that's the option they have.
yeah.
Okay, so there are some cases are very individual, very lengthy, which will be little bit difficult to carry. But there is a group of questions are around the trading, like say property, etc. During you are on a H1B, etc. So can you, because if you sell or anything, you will get 1099, and would they is it allowed? So there are questions around that. So anybody wants to take that?
CPA.
Yeah. So, doing any financial transaction is not restricted, especially if it is this is passive income. If they're generating income, of course, they cannot work for any other employer. Selling property or anything, whatever you have, should have no implication at all on this. So, if that is the question, I think I probably
Yes,
did.
yes, yes.
If
I
I
think
understood it
that was the
correctly.
right that was the question.
Yeah. Okay.
Um, yeah, I think that there is a question coming around that H1B got transferred. I still have a visa, like a previous I-4 one for this one, right? Should be there. So should I still get it stamped before the much more before the expiry, or we can go delay the going to India or anywhere to stamping?
I think I read the question. What he's asking is if it is still stamped and I've already transferred to a new employer, can I travel and come back? Definitely you can, though I always feel if it's all both good employers, stamp it and come back. Now you have the extended period to come and stay for a longer time, unless you're worried about an admin process because of some issue particular with your employer or your own case.
Okay. So, are there any restriction on F1 OPT person traveling to say Mexico or some other places on business visa, business for business purpose?
Well, if they have valid visa, and of course during that time, if they have valid employment, they should not be a problem in their coming back. They have a visa, they have an employment, they have a valid OPT. It should be okay to travel.
So
It's
there
only
is
when
a
they're
student
going in
on
the in between
H4.
time, then they have to be careful with the timing of their travel.
So there is a student on H4 in university for almost 10 years, didn't visit in India, and now question is that would visiting India will be a problem with stamping, and should I get any documentation from university?
Student on H,
F1. H4, yeah, I think currently H4. That is interesting. So it is a H4 at UC campus.
so
Haven't
then it will
traveled to
be
India
it's
for
tied
10
up
years.
to the H1 of the primary applicant, no? So then that is where it's there, and of course they have to see how much time it's taking for stamping, because now the time duration also has been cut down to 12 months for automatic stamping or a
Any
Dropbox.
precaution parents should take when they are coming on B2 visa, B1, B2, any things that particularly B2 over there?
I don't
Nothing that
think there
comes
is
to mind. Don't say I'm coming here to help my child.
there.
Yeah, they all start saying, my daughter is pregnant, I want to help her. You're just coming here to spend time with your children, not to help them. That is involuntary employment. I see a question there. I know lots of questions, but one of them is talking of a spouse being taking treatments in India, whether they can extend their stay. So a permanent resident can stay out for over a year, I mean, under a year, but don't come in saying my spouse is getting treated in a different country. Because when you're a permanent resident, it is assumed that you are taking health insurance here and all your treatments are being here. So come up with the reason might be that the spouse is getting treated elsewhere, but don't come in saying that I got delayed because my spouse was taking treatments or anything like that. There are a lot of legitimate reasons to stay out, which, you all can shoot an email to, I'm sure, Neeraj or to us, and we can go over those with you. But don't say my spouse is getting, or my parents were getting treated somewhere else, and that is not a legitimate reason.
Okay. Any guidance on this alien registration form? So valid H1 holders completing 6 years should register under that or no?
That is for people who have not had biometrics, right? So if you've had your biometrics, I don't see the reason why.
So any kind of delays are happening on JC or EB5 processing after this one? Anything that came up that the scrutiny increase or the delays are happening?
Scrutiny definitely increased. For people who are filing now, and I'm sure Neeraj is seeing that, the applications are being returned. We are on a lot of groups that we mentor for attorneys, and they are telling us that applications are being returned, complete packages, because the signature was not in the box. So then it goes to a border of not scrutiny, this becomes silly. So, generally speaking, I guess in this forum, I can say that the officers taking care of these things are, you know, just arbitrarily returning applications or doing that. And yes, scrutiny will increase. Yes, you'll see many more RFEs. As long as your petition is good and strong, there is no reason for you to think that it will be denied. We have sailed through this administration just before 4 years, and we did see a lot of RFEs, a lot of noise coming at that time also. But even then, I always felt that a strong petition was a strong petition. And whether there was an RFE or a NOID, it would sail through. They might come back more. We see a lot of silly RFEs coming our way, But that is not to say that you have to fear any denials or transfers. Timelines are, of course, going to get extended, not because of the administration, but because the lines are getting longer. We saw EB5s being approved within 7 to 9 months when we started refiling in 2022. And now I'm already seeing about 13 months to 14 months for the 526 approvals coming our way. So yes, the timelines are increasing, but because of the number of people that have filed, not because the administration has put a block somewhere.
So, Neeraj, you may have touched base with this question, but on the same OPT, there is just a clarity that a person is trying to switch the job or get the H1 or something applied. Current employer is not cooperating, and then the person feels that he may miss a few pay slips, that is, the payroll may not be there. So, would that be any issue? I think it's a transition case.
So he has to justify that he's working. The obligation to pay salary is on the employer. Of course, when they file the petition, he has to give this, but somewhere he should be able to establish that he is validly employed.
Okay.
So that
So,
is what he will have to.
question on H4, can H4 student attend college during the status change of status to F1? So, can someone?
Yeah, so long as H4 they can work, they can attend college on H4.
Okay. I think that's now the latest question. Let me see some of the latest question. I think that port of entry is coming. We covered that multiple times. So, is there any risk of EB1 premium processing getting rejected? I, I
I didn't get what is
I
that?
think it's just a
Did it
fear.
say that we will not do a premium processing for an EB1 or that the EB1 will be
So,
rejected?
question is that are there any higher rejection rates? I think it is.
No, no.
No,
Premium processing
the
is your
question I
better
think
one.
is whether premium processing causes any extra rejection rate, which I don't think so. Uh,
Okay. Um, so someone's got H1B is expiring in January and seeking that whether advice whether traveling in June, July, etc. For 3 weeks, would that be any hassle?
No,
They come back.
not at all.
So is there any kind of mandatory? It should be that before expiring, at least should enter X month before the expiry or something.
You
no,
know,
they're.
better safe. Yeah, better safe than sorry.
Mhm.
Come in time. Don't come just 1 week. To it. I have had a person fly in on the last day of it. So yes, you can enter until it is legitimately valid. But again, so many things we are seeing which can go south. And a CBP officer, when you're entering, has all the power sitting there. Your attorney cannot do. You could call me, your attorney, Neeraj, anyone. No one can really assist you at that time. So make sure you have enough time between your H1B. Suppose in say in the negative chances you are sent back for whatever reason, at least you have 3 4 months still left on your H1B where we can do something to bring you back in, or you come back in say after 2 3 weeks or whatever. So yeah, keep some cushion.
So a person on H1B needed to go to India for health reason may continue there for 6 months or so, having the iPhone 40 approved. The question is that would there be issues when they come back?
If they stayed out for 6 months,
6 months for health.
not a problem at all. Not a problem if you stayed out with your employer's permission. Express permission. You should always, again, because all these things we have seen in our practices. I've had someone who stayed out for 10 months, H1B physiotherapist who needed India actually for treatment, but we gave different reasons. She took the time off from her employer. She's not even working online. So yes, you can come back as long as it's legitimate.
And get a latest
Yeah, go
letter
ahead.
of confirmation from the employer that yes, they may ask whether after 10 months also, are they still waiting? Do you still have the job, valid job? So getting a latest letter from the employer would be desirable.
Very good. So this travel bans, whether it would impact EB2, EB3 category, would it reduce the backlog? Anything on that?
No, it's the travel ban is not related to those categories. And for India, nothing else other than our own population is impacting the EB2, EB3. Of course, the 7%. But other than that, it's just so many applications that we have pending. Somebody's asking about a special needs child. Sadly, the answer is no, you don't have any other options. You have your F1 to move your child to, that's it.
Yeah, I had a care where the person doesn't have the child doesn't have an option to move to another F1 because the mental age doesn't allow to get on F1 also. So
So any changes in
some
the advance payroll that, like say, would traveling on advance payroll is still active? Someone has it active H1, but it's not stamped, and then having question around the will advance payroll is sufficient or need to get H1 stamped?
Advanced parole is enough. It is sufficient. They can come back on advance parole without any problem. Again, when we make a blanket statement, yes, you can come on advance parole. Everything underlying should be good, right? Your underlying visa, when you got your H1, wherever you were working, there shouldn't be anything in your own record that could be harmful. It was a straightforward H1, now a straightforward AP because you filed your adjustment of status. There's nothing to worry.
Okay. Uh, this question is around the petition. If the petition document is lost and applied for a duplicate copy, is if this situation would cause any issues in travel for stamping and coming back from vacation, etc.
Travel is not related to your documents, it's only related to your approvals and your stamps on your passport. Petition documents being lost, I don't understand because if you're, say, going for a stamping, I think primary audience here is H1. And if you're going for stamping and you don't have something, say a copy of your LCA or a copy of what they had filed with USCIS, then maybe there'll be a question they'll ask which you might not have the correct answer because they do have a copy of your petition. So they know what has been entered. Other than that, there is no issue.
Any anticipation on priority dates on EB1? Would that be any
One
getting it
moved by
faster?
15 days. This month it moved by 15 days. So that's what it is. Last 2 months, I think a few months, it did not move at all. So this was a positive month for EB1. It did move. I do think that the wait time it will not go beyond the 3 years that we are seeing.
So a question around startup, that any question for the people working at startups to avoid issues if going to come back, going for a visa stamping. Neeraj ji, anything that you encountered?
So basically, more for startup because they don't have, they may not have revenue generation. So they have to have enough financial means. Maybe if they have funding, VC financing, they have to justify that the company employer has enough funds to pay for the H1B employment. That is the main thing.
A
Because
person actually wanted to, he's asking repeatedly that is there any way one can verify if employer is legitimate?
who's asking?
A person here, like a audience.
I mean, they have to do their own inquiry. Obviously,
They go to there are a lot of websites that will list the employers. You can also find out if this employer has previously filed for H-1Bs. I don't know which is, I just somehow just cannot remember it right now, but there is a website that has which verifies all the employers, which H-1B, the USCIS H-1B officers use. I wish I had that question earlier. I would have listed that website, or maybe I'll send it to Khandirao
Yeah, I
ji.
think we will be sending follow-up emails. So what we can do is that get the answers to the standard questions, and we'll be putting the
Yeah.
recording also and these questions so that we can send to, because a lot of people could not attend. I think our capacity got full or something. Unfortunately, so we'll take the some questions and send it on the email as well. Any major changes around? I think this kind of question getting repeated, but it's any challenges in getting L1 approved, yeah, L1 approved, and another is that any changes for students on F1. But essentially broader level, are there any changes? I think so. That's one thing.
Yeah, there are no real changes or as such as of now. So
Okay.
There
Uh,
is, let me quickly jump in because when I see a question that truly needs a response, there's someone saying the daughter is 20 and they have a F1 H4
H4, yeah, yeah.
3 years, and should they file for F1 or wait? Do not wait. Once she turns 21, that H4 does not matter. So file for F1 before 8 months of her turning 21.
Yeah. I'm on the O1 visa holder. I think then I'm processing, moving in one company to another company, planning to premium processing. Question is that would this impact my visa processing?
Did he say, what visa did he say? What visa is
O1, special category.
O1? No, I don't foresee any reason for them to have any issues.
Okay.
They can transfer easy. No, there's
It's
a
a question I think
prerequisite.
Raja, someone is asking, which is kind of repeated probably earlier, that someone one should travel on AP only for means advance parole only for emergency needs. Is that the case? People are getting grilled by immigration officer that AP is not a free pass, free entry or exit. Any comment on that?
Not true. You can travel and come back.
APS allows you to travel. That is the purpose. It's not a, it is a pass to allow you to travel while other adjustment are pending. That's why you're filing for it.
I think there are some minor issues coming, but they are kind of like say, while port of entry did not fill the shopping purchases, it was just given the zero. Whether this kind of goes on a record and creates a problem.
Not, I mean, no, but you should declare, not generally the questions that come up to us for immigration purposes. But yes, when you're coming in, whether a citizen or an or whoever, don't do anything which is going to make you later wonder, is it going to go on my record? Because that means there is some doubt in your head and you did not fill in things correctly. So don't do that. Just be truthful on everything. You should not have any problems later. Nothing
And
goes on
also,
record.
I just noticed some questions which are there. I mean, some of the facts are actually very limited facts. So there are many things which go all around those. There are other underlying facts also which have impact on many of the answers. So you can't just answer based on the limited facts which are there in some of the questions. So if somebody says, I can travel during this time or that, then what is the underlying thing? What is his situation? What is his F1 situation? What is his OPT situation? Or visa situation, whether stamping is there. A lot of other things are there.
Yeah, I think there is this question, yeah, was asked and in a different form, and you probably replied, but gentleman is asking again with a concern about son or child who is graduating and doing the undergraduation in May 2025, but visa is up to say January 2026. Yet to take the admission to masters, and then are there any issues to travel to India during the period? Any
If he's
advice?
taking admission, he can travel and come back. He'll have another I-20 with him.
Yeah.
Okay, then I think this is in general. I think yeah, Simaji, you mentioned earlier also that hey, valid visa holders should not be overly concerned and all that. But there is repeated concern coming. Like for example, should GC holders for several years consider U.S. citizenship simply due to travel and re-entry risk?
GC holder should consider getting US citizenship no matter what. But no, I don't foresee any issues unless again, as I think Neeraj also is saying that you need to know all facts. Suppose this GC holder who's asking me has two misdemeanors or even one misdemeanor, he definitely has a problem entering back. And that would be happening to a citizen also who's acquired citizenship. So those issues, yes, definitely you have to be wary of. Are they going to deport you from the airport? No. The only thing that can happen more during this time period for Indians is that you might be questioned at the. I tell everyone, just relax, just think it's your extra flight time. Chat with them, give all the correct answers, don't get upset or angry. Tell your parents coming from India if they ask them, just let them they know they're coming to visit their children. Be calm. If they take you for secondary questioning, parents who are elderly do get concerned and upset. Explain it to them that immigration can take you inside, but they just want to see that there is nothing wrong in your past. So that way, parents feel comforted and they don't mind answering all the questions. So, yeah, there's nothing to be concerned. Don't worry if you're questioned. Answer truthfully. And by truthfully, I don't mean you tell them I'm getting treated in India or, things which are not allowed.
Or I'm coming here to help my daughter.
Yes, not or yeah, that she's pregnant or that she works and I have to help her. All those things are employment. So they should not talk like that. That's why a lot of B1, B2 are denied because parents go and say all those things and they think it's a legitimate reason, which is the truth also. They're coming to help, but that leads to a lot of denials. So just be smart about that and, shoot an email. You have Neeraj right here, and I'm sure Khandirao can share the emails. And, if you can send your specific queries there so we can respond properly.
So someone basically came last year on H1B, changed the job in between, and now the question is that is it advisable to go to India for a stamping because there is a
So
job change?
for stamping, a lot of people have been asking questions. They have to factor in the appointment, which there have been long waits for
Great, yes.
appointment. So they have to get that appointment before, and that's something they have to do it, see when it is available and all that.
So I know that it is it is in court, but the question is still coming that any updates on birthright citizenship?
Nothing is going to happen to birthright citizenship also. So all of you who are listening to all these things don't change overnight. It would take maybe I don't know, 8, 10 years of hashing to remove it. By that time, the governments change. And whatever you're seeing right now, all these fears, if this government stays 4 years, so all of this is going to bounce back to normal in 4 years. And then we'll be calm, hoping that everything will start running, and then the government can change in the
Yeah.
next 4 years. So, this is a circle.
So particularly this birthright is in the court and it may take its own time. That's the first thing. And then if it requires a legislative change, then it's the next thing. It takes about and then typically it is a 2 years Congress. So it means that the current like a Congress may, if they continues, then Congress and Senate is all-star aligned right now. But after 2 years, it may not be the case. Generally, in USA, if you look at it, it has been last few decades, it has been flip-flop. So that way, don't be too much pessimistic into that. That's what I'm just repeating in the manner people would understand this.
Yeah.
May feel that it is we are trivializing, but it's not. It's a serious matter. It takes time.
Yeah, this is not going to, but
And finally, in what form, even if personally think there maybe it is just triggering a thought for in the minds of people. So something over the period may happen, some change, because amongst all the Western countries, probably US and Canada are the only one who allow in
which
this
allow.
form.
Mhm.
So that's one of the arguments which they have.
India doesn't allow,
Huh? No,
India doesn't
no
allow.
European country allows. So
Yeah.
that is one of those things which is there. But yeah, now the proposal is goes to another extreme, because even people legitimately on H1, those who have been born here for the last 10 years and all, they don't get any right. If it comes in this form, then there are valid concerns.
I think someone has a kind of lengthy question. Probably it may be better to capture it.
Yeah.
And I would say that people do send me an email. We'll try to see as much as possible, get categorized and try to answer. But it seems that someone basically filed I-140 in 2019, got approved, but that time missed to enter child in the information section of spouse and all children. So that's one thing. And then the child may be elder child date of birth is 2008 and will be 21 in 2029. I think is a pretty long time is there. So that's the question is that she will be in third year of bachelor of degree is much more forward looking question. But first question is the missed child, what to do?
What is
That can be rectified. That can be, you just need the birth certificate when you're filing for adjustment. If they qualify, they'll qualify with that
Yeah.
I-140, even if the name was not included. There's nothing to worry on. I do see a lot of CSPA questions, which is an individual question. They can always email.
Yeah, yeah. Okay.
PSPA is very tricky because of the lot of calculations in this, and each case is different. Generalized answers become difficult for those.
Okay, I think we are time up, but we'll take the last couple of questions and then wind up that EB2. And there was one question before this one was related to the remote working that person basically because of work from home policies or something was working from different place, then changed the home, but still within the 50 miles of radius. Would it come under NOIR?
No.
Ideally, they should do an LCA for all the location, even home. That's what we do for
Mhm.
so just to be on the safe side.
But
So
then if they change, you live in one apartment and then you
yeah,
move to another, I don't foresee any issues there or an amendment needed there. When you file your extension, then put the new address.
So there is one interesting question that the Department of Labor is about to delete historical H-1B records from the Foreign Labor Access Gateway. What is the impact of this?
To the beneficiaries who are standing here, no impact whatsoever. Why would they be concerned? It
Okay.
doesn't impact their LCAs. It's people who want to have a look at the data or do some kind of data analysis like lucid text and all that. But for a person filing for my law firm, it makes no difference whether I access that data, and for the beneficiary, it makes no difference.
One interesting case is the reverse case in a way that the child is now is a 20 years old. Can this child probably might have born here or something, but can sponsor parents' green card?
Definitely.
yeah, no, but I think one of the questions is GC child who's 21 years sponsoring
Oh,
parents. GC cannot.
GC cannot, yeah.
Yeah, so the child has to become a
citizen, yeah.
citizen to
If they were
sponsor.
born here, a lot of EB1, EB2s, and EB3s might see children sponsoring them instead of their green cards being approved because a lot of them have children born here. And then they file their I-140s, which will be delayed, whereas the child will be 21 and sponsor the parents.
Okay. I think we'll take the last question that do we need to file for I-140 within 6 years of H-1B? Is it mandatory, or if we don't do it, do we need to go back to India?
H1 duration will go. There's no way H1 can be extended unless there's a gap where they have been traveling out and they have not really stayed for 6 years on H1B. They can recapture.
I
Otherwise,
think
yeah.
we covered almost all questions, and thanks both of you for answering, and all the audience for patiently listening to this one. We'll be posting this recording in FIIDS channel on YouTube. We'll be sending email to all the registered participants. Many of them could not join because I think we fill with the capacity. But now at the tail end, I would request both Seema ji and Neeraj ji to give the closing remarks. Any couple of minutes comments both of you want to give? Simaji, go please.
Oh, okay. Well, wonderful meeting all you guys, and I hope we answered some questions, if not all. I do get when I see an immigration question, I want to answer them all. I think we covered quite a bit of base. My 2 cents would be don't worry so much. Nothing has changed except the news. And there's no substantial change in immigration. Anything that you're reading now is just maybe being written down. Everything is literally the same. The only thing different is higher scrutiny, which happens always. Yes, I see a lot more admin processes in H1 or in any other visa stampings. But other than that, nothing at all. Don't do anything wrong. Don't get misdemeanors, felonies, because that impacts your immigration a lot. Other than that, reach out to Khanderao-ji if you have more specific questions, and we can always respond to you.
Thank you. Neeraj ji, please go ahead.
Yeah, and I echo whatever Seema ji said, 100%. Yeah, there is obviously times are different, so one has to have their eyes and ears open all the time, and just be careful with everything. If they are traveling, their parents are traveling, family members are traveling, they have to be aware and just be prepared with all. If any documentation are required, don't take a chance. Have all the documentation, and whatever expected questions, answers are there, be prepared for those. And I think nothing has changed so far. Things are in the pipeline, so we don't know in what form what comes in. So till that, everything is there.
Thank you. I think the message is that don't overly get panicked. Be prepared. Have your documents. If you get question or parent get questions, calmly reply to them. Be patient. Don't get panicked. Don't get worried. And I think
Yeah.
you always have some limited but some rights I think you will have. So you will not be directly deported from the airport, etc. There are whenever I think there are some drastic changes happen, etc. We may host a session again that this is a recorded session. Questions we applied, we'll send the recording to all the participants, and I will share the email. And then if there are questions, please send us because lot of people had registered. I think over 300. We didn't realize that, and then only 100. I didn't know that there is a limit on this bridge. So many people could not join. We apologize that. Recorded session will be posted, and then just as a courtesy to all of them, I will take a little bit liberty, Simaji and Neeraj to answer some of the question at your convenience within say 1 week or something. We'll compile them and send it back. So everybody, thanks again. And once again, Simaji, it is late for you. And Neeraj, Simaji is in Dallas, and Neeraj is here. So thanks, everybody. And we'll connect.
Thank you, Khanderao-ji, and thanks to FIIDS. It was
Yes,
a pleasure
yes.
interacting with Seema ji also.
Same here. Wonderful. All right, Khanderao-ji, namaste to all of you guys.
They all-
Namaste.